SJC-08921, Commonwealth versus Chatman.
Good morning, Mr. Hayden.
Good morning. My name is Edward Hayden. I represent Damon Chatman. He was convicted of first-degree murder for killing his mother. Subsequent to that, a motion for a new trial based on lack of competence was denied by the trial judge. This court reversed that decision and in the process set a new test for determining when competence is raised post-trial. That the defendant now has the burden of proof by a preponderance that the prosecution would not have been able to prove that he was competent if the issue had been raised at the time of the trial. The test for competence, of course, remains the same, whether he was able to assist his counsel and whether he had a rational understanding of the proceedings. We all agree.
Sorry, but the standard for our review of Judge Rouse's determination is abuse of discretion?
That's correct, Your Honor.
So it's whether or not she abused her discretion in finding that the defendant had failed to meet that burden by a preponderance.
Correct. We all agree that Damon Chatman has had a long history of mental illness, and we all agree that those illnesses have symptoms. Where we part company is whether or not those symptoms were consistent throughout his life, or whether the symptoms waxed and waned and were in the waning stage for the entire 2-year period that he was held prior to trial.
Counsel, I just don't understand why you put so much emphasis on waxing and wane. How does that make this case go the way that you want to, whatever the answer to that question is? I had a hard time understanding why you put so much emphasis on that. So what if it waxed and waned, or if it didn't wax and wane? That's not the issue in the case.
I think the prosecution's argument is that his symptoms waxed and waned, and that for the entire 2-year period that he was held prior to trial.
So assume that they were wrong about that. What difference would it make?
Well, if his condition was in the waxing stage during this time period, then he was suffering the symptoms.
Okay, but you have to go from there to he's not competent to stand trial because of those symptoms. That doesn't get you there to say that the symptoms were present. That's not enough.
Well, no, but my argument is that the symptoms that he was displaying during this 2-year period and during the trial, that is the support for our argument that he wasn't competent, because he wasn't assisting his lawyer and he wasn't rationally understanding the proceedings, and those were symptoms of his schizophrenia and paranoia. And Dr. Joss evaluated Mr. Chatman and concluded that he suffers from schizoaffective disorder with paranoid delusions. And it was because of this illness that he was not able to understand the proceedings. I thought Your Honor was going to ask a question. And it was because he was not able to understand the proceedings and he was not able to assist his lawyer.
But if the judge discredited Dr. Joss's testimony, what should we be doing with that?
Well, I think it was an abuse of discretion for the judge to not credit Dr. Joss, because there was no basis for her to discredit him. There was, for example, Dr. Joss said that DeMond did not understand the proceedings, and I think the most egregious example of this is when DeMond told Dr. Joss that he thought the prosecutor had challenged the faggots and white girls from the jury. And Dr. Joss took the steps to determine whether or not DeMond was malingering. I don't think anyone claims that he was malingering.
But okay. However, Dr. Joss never saw him, saw him quite substantially after the trial, right? So this is all a retrospective
Correct.
view.
Right.
But the judge did see him, and so did the other witnesses at the time of the trial, right?
Well, I don't think, the other witnesses, if Your Honor is referring to the expert witnesses.
No, I was referring really to Mr. Bonastali, Ms.
Oh, I see what you're saying. Well, first of all, as far as the judge is concerned, DeMond did nothing during the trial that would indicate, there was nothing for the judge to rely on about her concluding. Now, in her first memo, her first decision that was decided without the evidentiary hearing, she concluded that, she saw DeMond and it was, he seemed fine to her. But he did nothing during the trial for her to form that basis. Now, in the second decision, she did not rely on that. The only time that the judge ever heard DeMond's voice is when he cursed at her in a motion for a new trial. So there was no basis for the trial judge to form any opinion whatsoever about DeMond's mental state. Now, as far as Mr. Bonastali...
What about the fact, couldn't she observe his demeanor during trial? And that he wasn't acting out, he wasn't doing a range of other things that people with certain mental illnesses display?
See, the thing about DeMond is he doesn't act out. He doesn't
Well, she could see all that he doesn't.
But he was just sitting there, not saying anything, not a true participant in his trial. He was just sitting there. I think the word used was he was inert. And so there was no basis for that opinion. And by the way, I think it's interesting that in her second decision, she didn't rely on what she observed about DeMond. The first time she relied on that, it didn't have any traction with this court. And in the second decision, it just didn't come up at all.
Well, because she had this evidentiary hearing and she had all these witnesses who testified, she had more to work with the second
if
time
she had
around.
more to work with, the only thing she had to work with was the experts who testified in favor of the defense.
Yeah, but she's not required to credit those experts. She could disbelieve Dr.
But
Joss.
I understand that, Your Honor, but it would be an abuse of discretion for disbelieving these experts with no valid reason.
Well, how about she disbelieve Dr. Joss because he formed his opinion 6 years before he testified at the motion for new trial hearing, and he never talked to the people who were actually there until the day before.
Well, I think also he was not at the trial.
Right.
And he formed his opinion a couple of years afterwards. However, there was no issue about the steps he followed. It's not impossible to form an opinion about someone's competence post-trial. It's not impossible.
But he formed his opinion based on things that happened after
Well,
the
not
trial.
really, Your Honor.
He didn't really talk to Mr. Bonastali.
Well, first of all, I disagree with Your Honor when Your Honor says that he didn't have anything to base on. We know that DeMond did not tell Mr. Bonastali about his history of mental illness. We know that, and he didn't tell him for the 2 years prior to trial and the 2 weeks of the trial. And that was a symptom of the paranoia. He wouldn't tell people about the illness. So by not telling Bonastali, he was displaying a symptom. And for the prosecution and the judge to claim that he didn't tell Bonastali for some other reason, they say he made a rational decision to not tell Bonastali, but they don't provide any explanation about why he wouldn't have told Bonastali. And it makes sense because every expert said that and from this court's opinion in the first time around, that the issue was, did his illness work to conceal itself? And every expert said that it did. And so when he doesn't tell Bonastali that he had a history of mental illness, he is displaying a symptom of that illness. And to disregard it without any reason, the prosecution did not call an expert. They did not have DeMond evaluated. There is absolutely no support for their position that the condition waxed and waned. I mean, what they have to say.
Because you had the burden of proof at the
I understand that. However, their position is that his condition waxed and waned. And that for the entire 2-year period that he was held prior to trial and was dealing with Mr. Bonastali, they have to claim that his condition was in the waning stage, because they're saying he made a rational decision, and in order for him to do that, his condition had to have been waning.
Are you saying, though, that just by virtue of having schizoaffective disorder with paranoid tendencies, if that's what the diagnosis is, that by in and of itself makes a person incompetent?
No, of course not, Your Honor. I mean, but we didn't stop there with just the diagnosis. Joss linked the symptoms of those diseases with what DeMond did. He didn't tell Bonastali.
You cannot tell somebody. That doesn't necessarily mean you're incompetent, though. I mean, that's why it sounds like it is the diagnosis that you are saying makes him incompetent.
No, the symptom of that diagnosis.
Of not telling
Of
him
not
that he's
that's a
sick?
symptom.
That's a symptom, but why does that mean you're incompetent to stand trial?
Well, because he didn't assist his lawyer. Even Bonastali said that he would have wanted to know about DeMond's mental health history.
Didn't assist him in that respect.
I'm sorry?
I didn't assist him in that respect, but didn't Mr. Bonastali say he thought that he was communicating just fine with him about other aspects?
Yes, I mean, that's what Bonastali thought, because he was fooled. DeMond was hiding the illness, but we know from Mr. Bonastali's testimony, he would have wanted to know about DeMond's history, because he would have done something with it.
Well, he might have made a lack of criminal responsibility defense, but that's different from being incompetent to stand trial.
Oh, I understand that, but what I'm saying is, it's not like DeMond's mental health history meant nothing to Bonastali. I mean, if Bonastali had testified, well, even if I knew he had this schizophrenia and paranoia, I wouldn't have done anything with it, because I would have gone forward with an alibi defense. But Bonastali didn't say that. He said he would have used that information, because as it was, what he was stuck doing is going forward on a hopeless alibi defense. And he forewent with a viable mental health defense. Now, in that, whether or not that the first prong.
You know, people that have, I mean, the fact that you may not advance the most helpful defense to yourself doesn't equate with being incompetent to stand trial, though. I mean, I don't think it's unusual for somebody with mental illness who doesn't come close to being incompetent to stand trial, doesn't want to use a mental illness defense.
Well, but they never had that discussion, Your Honor. I mean, if someone can make the rational decision to not use a mental health defense, then they are stuck with the consequences of that decision. But if the decision is driven by mental illness, as it was in this case, then they are not competent, because they didn't provide their lawyer with all of the information that he would have wanted to use.
Okay.
And again, the prosecution didn't have DeMond evaluated, and there is absolutely no support that he made a rational decision to not disclose his mental health history, and there's no support for their position that he made that decision rationally, and it definitely would have had an effect on the trial. The question is, why didn't he tell Bonastali about his mental health history? And the explanation is because he thought Bonastali looked like a cop. And they discredited Dr. Joss's opinion because he had never viewed Mr. Bonastali. So, I mean, if Joss had taken some sort of view to determine what Bonastali looked like, what does a cop look like? What does he, I mean, if Joss came back and said, yeah, Bonastali looks like a cop, does that make Damon rational? Or if Joss comes back and says, Bonastali doesn't look like a cop, do you think the prosecution and the judge would agree, well, if Bonastali doesn't look like a cop, then Damon must be irrational? I mean, that is a invalid reason to discredit Dr. Joss, because the point is that Damon did not trust his lawyer based on how his lawyer looked. And that is the basis for schizophrenia. He was misperceiving and misinterpreting what was going on at the trial. And he formed the opinion that his lawyer couldn't be trusted based on how he looked. Now, there may be a valid reason for some client to not trust his lawyer, but that didn't exist in this case because who cares what Mr. Bonastali looks like? And Your Honor was mentioning earlier about that Joss had not spoken to some of the trial participants. I mean, he spoke to Bonastali a day before his testimony. However, there is no indication in the judge's decision on the prosecution's brief that what Bonastali had to say would have affected Joss's opinion. Bonastali...
That's unfortunate, because Bonastali's information should be highly relevant to his opinion. How can you say that?
Because
if he declines to consider the one person who has the most information and insight about what Mr. Chatman's mental state was, his competency was at the time, and he doesn't talk to him?
Well, no, first of all, Judge, he did talk to him. I mean, it was the day before his hearing. However, Bonastali didn't know what he didn't know. He did not know that Damon had this mental illness. So even if, just the fact that Bonastali testified, and I presumably told Dr. Joss when they spoke, is I thought we were communicating. They weren't. I mean, one of the reasons I think the judge abused her discretion is that she said that there was no evidence of a breakdown in communication between Bonastali and Chatman. Well, clearly there was a breakdown. It's an abuse of discretion to disregard the fact that Damon didn't tell him about his mental health history. And Bonastali would have wanted to know that.
Is there any indication that Bonastali asked him about his mental health history?
Didn't ask. Didn't pick up on anything.
I know, but
He
that's
didn't
not an
ask.
unusual question to ask.
Well,
one's
particularly in a
client.
first-degree murder case. But I mean, he just didn't ask. He didn't.
Okay.
He did not pick up on any of the signs. And all of the other experts said the same thing. Damon hid his illness. And without knowing his mental health history, he sat through that trial. He was inert. Now, the prosecution relies heavily on some DOC records that were generated a day and several days thereafter. When Damon, after the conviction, he went to DOC. They didn't pick up on anything either. He was inert, just like he was at the trial.
Well, they said he was euthymic, if I'm pronouncing euthymic is how you say it.
I don't know how to pronounce it either, Your Honor.
But I mean, it was more than one of them described him in that way. That's not inert.
Well, but they didn't pick up on his illness. Let me put it that way. But he lied to them about his mental health history, and that is consistent with his symptom.
Well, Mr. Bonestali did talk to Dr. Baxter, about the possibility of an insanity defense. That's what the judge found.
Right.
So
But-
it wasn't like he was totally oblivious to the issue.
But it was not because he picked up on any issue about DeMond's mental health. He spoke to Dr. Baxter because the alibi defense was so weak. He was just searching for another defense. And he got erroneous advice. I mean, the doctor told him, well, you can't go forward with an insanity defense if the guy is denying he did it.
All right, thank you.
Thank you.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. With me today is Mark Lee, who is the trial prosecutor in this case. We ask you today to affirm the denial of the defendant's motion to suppress. She properly found that
Not suppress.
suppress, sorry, his motion for new trial. Normally it's a motion to suppress. She properly found that the defendant failed to meet his burden to show by a preponderance of the evidence that the Commonwealth would not have been able to prove that he was competent at trial. She actually goes one step beyond that, and this is on page 20 of her decision, page 170 of the record appendix. She finds that the defendant was competent. She finds that he had the sufficient ability to consult with his attorney with a reasonable degree of rational understanding. And she, in the next sentence, ruled that the evidence was abundant that the defendant had a rational
Can I
understanding.
ask you a question about the standard that was articulated in Chatman 1? The court said that when it's not raised at the trial, that the defendant has the burden to prove that the Commonwealth could not establish. Does that put any obligation on the Commonwealth to come forward with any evidence at the motion for new trial hearing? Because the Commonwealth didn't present any
Sure.
witness in this case, and I am not sure how that's supposed to work.
Sure. By its very language, I don't think the burden still remains on the defendant to produce evidence. I'd say that where the Commonwealth chooses not to affirmatively produce its own evidence, it does so at its peril. I can tell you that in this case, based on the testimony of Attorney Bonestali, who testified extensively about his communications with the defendant and the defendant's ability and how exactly he assisted with his defense, the testimony of Attorney Church, specifically the cross-examination of the 5 doctors who testified at the hearing, specifically the cross-examination of Dr. Joss. It was just our opinion that it wasn't necessary to provide an expert to offer any opinion in support of our position.
Did Dr. Baxter herself actually ever meet the defendant, or was that just a conversation between her and Mr. Bonestali?
She never met with the defendant, and I would like to clarify, I believe Attorney Bonestali's testimony was that he didn't remember ever having a conversation with the defendant about any mental health history, not that it never occurred, not that he never asked the question. He specifically testified that due to the nature of the crime itself, that it's something that he looked into. That's why he contacted Dr. Baxter. But he also said that where the defendant in this instance was so adamant that he was innocent, was so adamant that he did not kill his mother, where he consistently presented the same alibi defense from when he spoke to the police to when he interacted with his attorney, that it was just his opinion that it wasn't feasible in this instance to have researched or presented a criminal responsibility defense. I'd also like to address, my brother contended multiple times during his argument that one of the symptoms of the defendant's mental illness was that it worked to conceal itself. He said that every single expert testified to that, and I disagree with that contention. There were 5 doctors who testified, and none testified that one of the symptoms of the defendant's mental illness was that it concealed itself. The only one who came close to saying this was Dr. Joss, and this can be found in volume 3, page 109 to 110 of his testimony. And he gave an opinion that the defendant was paranoid at the time of his trial, that this paranoia caused him not to trust Attorney Bonestale, and that this lack of trust made the defendant, and I'll quote, just not reveal anything about his significant mental history.
What, how long after the trial did Dr. Joss first interview the defendant?
He first interviewed the defendant sometime in 2005, and the defendant was convicted in 2002, so it was 3 years. I believe he rendered his opinion as to the defendant's competency sometime in 2006, so it was 4 years after.
And during the time between 2002 and 2005, was the defendant taking medication?
He was intermittently taking medication. If you look at his, I think, the prison records from the DOC from 2002 to the end of 2004 were before the judge. When he first presents at the prison in his intake form the day after he's convicted, he's not taking any medication. I disagree with my brother's contention that during that time he continued to conceal his mental illness. He does speak with the, I think it's a mental health counselor, about a previous psychiatric history, the fact that he had taken Thorazine, been prescribed it before. He continues not to be on medication, and he continues to present as completely not showing any signs of mental illness to the mental health individuals he comes in contact with until February 19th of 2002, so about a month after. At that point, he has interactions with Dr. Marion Smith. She noticed a marked difference in the symptoms that he's displaying. And at that point, from 2002 to 2004, there's a progression. You'll see his symptoms vary wildly, and they're trying out different medications. At certain points, he won't take medication. He's on medication. They're trying to find a balance of what will work for him. I would also note, though, that if you look at the records from when the defendant was in custody before his trial, they also corroborate Attorney Bonestale's testimony that there were just no symptoms of mental illness, that the defendant was not presenting in any way that would suggest he was showing those symptoms. And specifically the Suffolk jail records, which were before the judge and are before this court, you'll see that starting in April of 2001, where the defendant self-reports that he's suicidal, he has frequent contact with mental health workers, mental health evaluators from April 2001 until July of 2001. And in those records itself, they're saying that there's no paranoia present, that there's no psychosis present, that the defendant is not presenting any symptoms that would suggest that he has any sort of mental health problems that is affecting his ability to communicate with them. So again, the prison records from, and the same is true in September of 2001, he's transferred from Suffolk to the Middlesex prison because of threats that were being made against him by certain inmates. There's an intake form there where they talk about the previous suicidal thoughts, and there's nothing to indicate in the Middlesex records either that there was anything to suggest that the defendant was displaying any of those symptoms. But more than that, looking at the judge's careful opinion, there is simply no basis to find that she abused her discretion in discrediting Dr. Joss's opinion or in ultimately concluding that the defendant was competent at the time of his trial. We also, if there are no further questions about the motion for new trial, I'll turn to the 33E review. We urge this court not to exercise its power under 33E. There was no miscarriage of justice in this case. This was a case in which there was strong forensic and physical evidence that the defendant killed his mother. And there's simply nothing in the record, at least that I could find, that would suggest that there is a substantial risk of a miscarriage of justice.
Can I ask you, so is the only issue before us the denial of the motion for new trial, or is the entire appeal back before us?
The entire appeal, from my reading, there were no claims raised on direct appeal. If the court, in combing through the record, does find something, the Commonwealth would like the opportunity to be able to respond. As I said, I tried to do it. Obviously, I'm not a defense attorney, but I didn't see anything that jumped out at me.
Thank you, Counsel.
All right, thank you.
Thank you.
We'll take our morning break.